then we would have lost out without participating. Our prayer would be
He's arguing the application. We are taking so long.
Just tell us, Mr. Clarence, whether this petition you want it to stand alone or whether you want it to be consolidated with the petitions before the court.
That's where I was going to go.
Just go there, please.
We would be seeking that the petition be consolidated with the petitions relating to both the impeachment process and the filling of the vacancy that arises from impeachment. The reason being, upon filling of any vacancy...
Okay, we have heard you. You are agreeable to this petition being consolidated with the petitions which are in file number 565 of 2024.
My Lord, may I just conclude? My Lord, may I just conclude that I will be willing to compromise our application, provided that we can be allowed to participate in the applications for conservatory orders that are before the court, in the interest and in time.
With your permission, my Lord, I appear for the first respondent.
Yes?
And my Lord, I noted that we didn't come with our file.
Is this petition post-Senate proceedings?
No, my Lord. It has no relation with the post-Senate. It was filed, my Lord.
Before?
Before. And it has no touch on issues, my Lord, that happened at the Senate. Ordinarily, my Lord, will be opposed.
So we mentioned this matter...
Tomorrow, my Lord.
We mentioned this matter on 29th when the petition number 522 will be mentioned.
Most of likely.
Tomorrow or the 29th?
My Lord.
Yes?
I'm not sure if the court got the last statement I made. It would be greatly prejudicial to us if the discussions relating to the conservatory orders continue without our participation, because we are essentially raising the same issue in our application.
My Lord, I agree. We filed our application on the 8th of October 2024 before the National Assembly had even made its impeachment, had impeached Deputy Brigadier Gachagua, my Lord. We are acting in person, we are laymen, my Lord, and we are also protected by the same laws, Article 27, Article 47, 48, and 49, and 50, my Lord, for the right to a fair hearing. So we do ask the court does mention our matter tomorrow so that we can articulate the points that we need to.
My Lord, I appreciate the fact that the petitioners are appearing in person. And my Lord, once the court has made an order, my Lord, the only remedy available to the parties is either to appeal, my Lord.
We have not made any order. You know, we talk before we make orders.
My Lord,
so we mention this matter tomorrow.
Will be available.
We took. Which one? Which one is next?
I think 572. Hopefully it's the last one.
572? 572?
My Lord, the presiding judge, my Lord, my lady, doctor, it pleases you in the matter. My name is Wamboi, Shadrach Wamboi. I have the honor and privilege of introducing counsels for the petitioner. I appear alongside my learned senior, Mr. Dunstan Amari.
I'm present.
Mr. Samson Nyaderi, my senior.
I'm present.
My learned colleague, Mr. Nicholas Karanja.
I'm present.
And my learned colleague, Miss Melissa Omeda. We all appear for the petition applicant. Thank you.
Yes.
My Lord, in that matter, I am Shadrach Moses, the Solicitor General, appearing for the Attorney General, together with Professor Gitu Muigai, Senior Counsel, Emmanuel Peter, Deputy Chief State Counsel, Charles Mutinda, Deputy Chief State Counsel. Much obliged, my Lord.
Thank you.
My Lord, if may please in the matter. Milimo, my Lord. I appear alongside Ole Kuyoni for the first respondent.
May please you, my Lord. For the second respondent, my name is Gumbo. I appear together with the learned senior colleague, Mr. Paul Nyamodi, and Mr. Honorable Gitonga Murugara.
Wait, please, my Lord, my lady. That matter, my name is Edwin Kelly. My Lord, I appear together with my senior Professor Ojienda. My Lord, Senator Hilary Sigay, and Ms. Mercy Kanji. For the third respondent, my Lord, in respect of his matter.
For the third respondent.
For the third respondent, the Speaker of the Senate.
The Deputy President is the interested party, and I appear with my colleagues, Mr. Ngoya, Toma Charia, Jomo, Devwa, Kimpa, Wandati, Victor Swanya, Faith Muge, Faith Waibu, and Mr. Muge.
And Mr.
Muge, for the interested part, that is the deputy president.
Thank you, my Lord. My Lord, just to respond to the question whether this petition should be consolidated with the others, the questions that have been posed in the instant petition question the constitutionality of the impeachment process at the Senate that led to the removal by way of impeachment of the Deputy President. Secondly, my Lord, it also questions the constitutionality of the appointment of Professor Kithure Kindiki as the Deputy President designate in that office. And for that reason, my Lord, the view that we take with humility is that the petition is ripe for consolidation, and my Lord, just for the avoidance of any doubt, and my lady, we have an application filed and dated the 18th day of October 2024 that sought an order of conservatory order to stop the implementation of the decision made by the Honorable Speaker of the Senate, Honorable Amason King. So, my Lord, when we canvass or we are to canvass the applications as to whether the current conservatory order should be disturbed or not, we want to actively, and we seek with humility, to participate in those proceedings. Thank you.
Is there, the parties, are you opposing the possible consolidation?
Yes, my Lord, we are vehemently opposed, my Lord, to the jointer or intended consolidation of this petition. And but also that we don't take time before you this evening, we will prefer, my Lord, that this matter also takes the cue of being mentioned tomorrow with the other, my Lord, where we will substantively, my Lord, be presenting, my Lord, before you reasons why this matter should not be consolidated with the one that is before you today. And my Lord, so that we save time, I speak for all the respondents.
Mention tomorrow.
Sorry, my Lord.
Mention tomorrow.
We mention tomorrow.
Yes.
My Lord, if you permit me. My Lord, there is a mischief that we need to cure or to safeguard ourselves against. My Lord, there is an attempt to have a litigation by way of installment in this matter. So much so that, my Lord, if you look or you find time to look at the petition and the application, you will see that the issues that are raised by my seniors and counsels for the petitioner are synonymous, they are the same.
So since it is not consented to, why don't we listen to it tomorrow?
Most obliged, my Lord, because the question of consolidation is a question of law and it's purely on a principle question.
Yes.
And, my Lord, we will be ready to argue the question of consolidation as and when we are invited. Thank you.
All right.
Yes, please.
Proceed.
And my Lord, my Lord and my lady.
Yes.
Yes, I am guided by my senior counsel, Paul Muite. The question of consolidation is one that even the bench, as it is currently constituted, can actually look at the matters and on its own motion, suo motu, give directions or orders, whether it is deserving to be heard alongside the other matters, or we just need to take a cue behind other petitions.
So, my Lord, the court has spoken. We'll mention it tomorrow. Thank you.
Let's consider that issue tomorrow.
Most obliged, my Lord. Thank you.
572.
This is the
522.
This is the
522. This file has a mention date for 29th of October, but because issues are arising, we wanted to mention it again today if there is any issue arising out of it.
In terms of appearances, and in order to save the court's time, the same counsel that I enumerate are appearing for the petition, the deputy president, with this matter.
Yes.
Yes, my Lord, for the respondents, the quorum is similar, my Lord, so that we save on time. My Lord, we will be willing, my Lord, to present before court two options. Either, my Lord, we retain the mentioned date that has been given, or, my Lord, you mention the matter tomorrow, so that if there is any party who will want to address you, will address you tomorrow, my Lord.
We don't want to back tomorrow with so many matters. If there's no need, we can retain the 29th.
We can retain the 29th, my Lord.
This is the big file, isn't it? So we have to mention it because it is the big file.
Okay, we can mention it tomorrow. Let's mention the matter tomorrow. So we are clear with the mentions. We can go back to petition number 565.
No, you have not mentioned my matter.
Which one?
509.
509. It was consolidated in 5.
Sorry, I'm sorry, I never heard you call it out. I'm sorry, Mr. Kit was keeping me busy giving me. My Lord, in that respect, we have an application. I hope it's on record. We could also mention and get directions tomorrow on my application for the recusal of the bench dated the 22nd. I would be most obliged, Lordship.
We are mentioning the matter tomorrow.
Most obliged.
So then we are back to the petition number 565.
We wish to confirm that on the part of the Attorney General of the Republic, we are ready to argue our application certified urgent by this court or by the court referring the matter to this court.
I believe this is the matter that we had earlier indicated, that after all these matters have been considered, directions have been given in these matters, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out 3 things. Number 1 is that we would need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number 1. Issue number 2, my Lord, that is important, is the fact that now that today the Honorable, the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment was done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court, appearing there, assuming there is no other preliminary issue like recusal or other ones. Thirdly, my Lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated. And more importantly, my learned colleague, Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my Lord, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you do not get faced with a fait accompli, where you are told we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My Lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Your Lordship. Your Lordship, there is
This, you can see that we are consulting.